Hello and welcome to Courts Today by LiveLaw. Let's get to today's top legal updates. Supreme Court refuses to suspend Sanjiv Bhatt's life sentence in 1990 custodial death case. Supreme Court declines fresh writs against Waqf Amendment Act. Asks petitioners to join the ongoing case. Supreme Court reduces sentence of mother who killed her daughters, cites lack of motive as a key factor. CJI tells lawyer not to make political speeches while urging listing of Collegium petition. No issue with spyware for national security. Supreme Court says question is who it's used against. Why is BCI interfering with academics? Supreme Court seeks Center and UGC's view on one-year LLM course. I'm your host Syed Amir Hussain with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelawmedia.in. Please make sure to watch this video till the very end and don't forget to like, share and subscribe to our channel, because your support means the world to us. The Supreme Court today refused to suspend the life sentence of former Gujarat IPS police officer Sanjiv Bhatt in the 1990 custodial death case of Prabhudas Madhavji Vaishnani. A bench of Justice Vikram Nath and Justice Sandeep Mehta rejected Bhatt's bail request but directed that his appeal be heard soon. Bhatt was convicted in 2019 for the custodial torture that allegedly led to Vaishnani's death, 10 days after being released on bail. The incident occurred during a Bharat Bandh when Bhatt, then ASP Jamnagar, detained 133 people. Bhatt and another officer were sentenced to life under IPC sections 302, 323 and 506 clause 1. His appeal against conviction was dismissed by the Gujarat High Court in January 2024. In the Supreme Court, senior advocate Kapil Sibal argued there was no evidence of torture and that Vaishnani died from existing medical issues. But the Gujarat government, represented by senior advocate Maninder Singh, said medical reports linked his death to police-inflicted stress and torture. The court noted Bhatt's ongoing 20-year sentence in another case and declined to suspend his life term. The Supreme Court today refused to entertain any new writ petitions challenging the Waqf Amendment Act of 2025. A bench led by CJI Sanjeev Khanna said all fresh petitioners can instead file applications to join the ongoing main case as interveners. The court is already hearing 5 key petitions and said it won't accept duplicate or similar filings. Petitioners like J&K MLA Arjun Singh Raju, MP Derek O'Brien and others were asked to file impleadment applications if they wish to raise additional points. One petitioner argued that the term Waqf from the Quran had been misunderstood in the new law. Another sought protection for the Waqf Assets Management System portal. The court made it clear that no petitioner will be denied a hearing. They just need to follow the process. The next hearing is scheduled for May 5th. The Waqf Amendment Act came into force on April 8th after being passed by the Parliament and receiving the presidential assent. The government has defended the new law in a preliminary affidavit before the court. The Supreme Court has refused the life sentence of a woman convicted for killing her 2 young daughters aged 3 and 5 by changing the conviction from murder, section 302 IPC, to culpable homicide not amounting to murder, section 304 part 2 IPC. The woman, who had already spent nearly 10 years in jail, said she was under an invisible influence at the time of the incident. The court noted that while there was no medical proof of mental illness, her behavior was strange, unexplained, and showed signs of mental instability. There was no motive, no attempt to flee, and she kept crying and repeating that she had killed her children. The court said this raised doubts about her intention and that the absence of motive supports a possible insanity claim, while not granting her relief under Section 84, which is unsound mind. The court acknowledged her rural background and lack of awareness about mental health. Based on this, the court ordered her release considering she had served the maximum sentence under Section 304 Part 2, which is 10 years. In a sharp exchange today, Chief Justice of India Sanjiv Khanna stopped Advocate Matthews Nedumpara from making what the court called a political speech during a plea mention. Nedumpara was trying to revive his 2022 petition challenging the Collegium system of judicial appointments and advocating for the National Judicial Appointments Commission, which is NJAC. He claimed the Vice President and people of India support NJAC and even said the court had earlier promised to list the plea. The CJI firmly interrupted, saying, "Do not put words in my mouth. Do not make a political speech in the court." The petition had earlier been rejected by the Supreme Court Registry, which said the issue was already settled in the 2015 NJAC judgment. It also pointed out that the plea was essentially a disguised review of that judgment, which is not allowed under Article 32 of the Constitution. According to court rules, the registrar has the power to refuse petitions lacking merit, although the petitioner can appeal the refusal within 15 days. In the Pegasus Spyware case, the Supreme Court on April 29th observed that owning spyware for national security is not wrong, but using it against private citizens raises serious concerns. A bench of Justices Suryakant and N. Koteswar Singh was hearing petitions alleging surveillance of journalists and activists using Israeli spyware Pegasus. The court allowed petitioners to submit a US court ruling where WhatsApp confirmed that Pegasus was used to hack users, including in India. Senior advocate Kapil Sibal urged disclosure of a sealed report from the Justice Ravindran Committee, which had investigated the matter in 2021. While the government opposed full disclosure, citing national security, the court said only individual specific parts may be shared. The center had earlier refused to confirm if Pegasus was used. The committee's report found malware in 5 of 29 submitted devices, but couldn't confirm if it was Pegasus. The case will be heard again on July 30th. Petitioners include journalists, activists, and the Editors Guild of India. The court emphasized that national security cannot override citizens' right to privacy without scrutiny. The Supreme Court has asked the Union Government and the University Grants Commission or the UGC to share their views on whether the Bar Council of India or the BCI can regulate academic affairs in law universities. A bench led by Justices Suryakant and N. Koteswar Singh was hearing challenges to BCI's earlier decision to scrap one-year LLM courses and de-recognize foreign LLM degrees. The court questioned why the BCI was interfering in academics instead of focusing on lawyers' training. Justice Kant said legal education should be handled by experts and not just BCI. The court asked the Attorney General and the UGC to file detailed responses. BCI's lawyers said an expert committee led by former Chief Justice is being formed. But petitioners argued BCI is overstepping by trying to control even PhDs and diplomas, which fall under UGC's domain. The court emphasized LLM is not a qualification for practicing law and should be managed by academic bodies. The next hearing will further clarify the roles of BCI, UGC, and the government.